Thank you for this introduction, and once again, thank you for inviting me here, because I'm really proud to be among such experts in the field of video gaming and IP also, as well as intellectual property. So I am Karolina Potrawka. I'm working with SSW as an associate in IP&AI team, and today I'm going to go through game elements subject to copyright protection and means of their protection on the digital single market. So the idea of digital single market might be surprising for some of you, because the idea of the digital single market and the legislation is quite, I would say, kind of outdated, because this discussion has been going on for the last few years, I guess. But the situation in Poland is quite different, because we have a 3-year delay. We have finally implemented legislation concerning the digital single market. So those solutions are new here in Poland. So first of all, in terms of global gaming market, I believe that it's one of the fastest growing sectors of the digital industry, with evaluated growth of 15% each year, and I believe that this value will be higher and higher every year. And the game is one of the most complex parts of the digital sector, and in terms of protection of the IP, as it combines elements from different fields. It combines audiovisual elements, as we've already discussed previously. It combines technological solutions, as we've also run through before, but also in terms of games, we have another elements that are subject to strict IP protection, regular one, such as, for example, the storyline, the character design, soundtracks, interfaces, game engines, or, for example, such elements particular for the for video games, such as, for example, sound bites, or representing images of different characters. So the debate over the character of protection has been going on for a long time, since the first application for patents, or first applications for protection, regardless of the copyrights, have been with us for the last at least 20 years. So this is not a new issue, but the debates are still ongoing, and there are no final conclusions therein. So, for example, while preparing a AAA game, you're working on unstable ground, so you need to have really good IP management policy introduced within your company in order to decide which elements should be subject to further protection apart from copyrights, and which are not worth disclosing at the moment of preparing materials. So for example, for AAA games, you are kind of gambling while preparing them in order to secure them in a proper manner. So the key questions for today is how these game elements can be protected, and I would like to address the similarities and differences between copyright law protection and industrial property law, as well as trade secrets. So in general, the definition of video game highlights the programming part. So video game constitutes a complex material that includes not only computer software, but also graphic and audio elements, which, although encoded in programming language, are not the key factor therein, and the video should not be assessed solely from the perspective of programming elements. In terms of basis of protection, we have copyright, we have industrial property rights, and unfair competition. And in terms of the difficulty of obtaining protection, I believe it's the most reliant one is copyright, because it does not require taking any actions in order to obtain protection, and it's granted in Poland at least automatically. It doesn't require any cost. There is a low threshold of protection also. And in Poland, there's a separate regulation concerning computer programs, which can be helpful in terms of obtaining protection. So in terms of industrial property law and requirements, the threshold is quite higher than in terms of copyright law. We also have fees to be paid, which are in general not that high, but the whole procedure is long and can really requires a lot of finding a lot of documentation, and also the outcome in video game industry is not that obvious, as we have already discussed today in terms of obtaining patent protections. We also can rely on unfair competitions. Unfair competition regulations, which protect our trade secrets, and protection of trade secrets is really helpful in terms of protecting the elements that we are not willing to disclose at a certain point of game production. So as an example of the elements of game that can be protected, we have here code, user interface, and engine, merchandising, choreography, music, sound bites, or dubbing that are subject to copyright protection. Also, there are several key elements that can be patented. For example, methods for managing characters, also some mechanics relating to, for example, controllers, or specific vibration, for example, as we've already heard today, for the DualShock and Sony. We have also methods of editing, which constitute our know-how. And we have data which is subject to as copyright, as well as database regulation, which is sui generis protection. There is no protection of concepts and ideas, as previously explained. So I will not delve into details regarding the concepts. But I believe that it's worth mentioning that for the sole concept, we have issues with obtaining protection for this. So as far as copyright is concerned, in video games we have literally elements such as programming codes, source codes, and variations thereof, plus artistic elements such as audiovisuals or graphics or images that are used. And the protection can be obtained for the game as a whole, as well as for the elements separately, regardless of which of these elements is dominant in production. So we cannot state that, for example, a game is mostly based on programming resources, so we need to obtain, we can only obtain copyright protection for literally elements, because that would not be the case in Poland. But the game is protected as a total work. So in terms of copyrightable elements, we have scenarios, we have graphics, source code, output code, movies, music, graphical user interfaces, artistic performances relating to using images of third parties, dubbing, characters, cities, or objects such as used armor or equipment of our characters. The main question here is whether we can protect elements which are generated by the AI, but this issue I will discuss later while going through the recent trends in IP protection in the game industry. So we have to keep in mind that sometimes we are allowed to use some IP that belongs to another party, and we can rely on some kind of exceptions. We have the fair use doctrine, which is used in the United States, in Poland, we have permitted uses cases, which are indicated in the Polish Copyright Act. So we have panorama law, parody, pastiche, or caricature. So we can base on them and use elements from other works in order to involve them in our game. So in terms of trademarks, I believe that we can go through the industrial property law and the solutions that are available for us there. So trademarks are one of the most important elements used in games right now. As we can see, for example, here we have EA Sports trademark that have been registered in the European area. We have also examples of other studios that are frequently used. We use trademarks, for example, to gain additional protections for our game name or characters' names. So it is widely used in gaming. We have also situations where we obtain license, for example, in order to use logos in other productions. So the main issue relating to trademarks in Poland right now, since I am working with esports also a lot, in Poland we have no exemption for using trademarks in sport events, and thus esport is categorized as sport. In Poland we are not, in general, we need to obtain licenses in order to use such trademarks. So we have, in case of trademark using, we have also high-class cases involving, for example, using Ferrari in GTA games, or the case between AM General and Blizzard relating to the use of particular form of tanks. So another form of protection would be industrial designs, which are called small inventions, and they protect elements that are new and have individual character. So in overall, the appearance of they make different overall impressions. So for example, industrial design protects the external visual elements, such as game controls or game pads. For example, here we have we can see two industrial designs that have already been registered. In terms of novelty of such solutions, because as we can see, all the controllers look similar to the ones that have already been registered with small differences, but even in this sector we have some really innovative solutions. For example, Microsoft has introduced two game consoles which are created for people with, in order to obtain accessibility for persons who are otherwise unable to use normal controllers. So with the European Accessibility Act on the horizon, it is really important that companies are creating additional solutions in order to increase the accessibility, regardless of whether the European Accessibility Act applies to them or not. The companies are doing a step forward. People who do not have access to the regular standard controllers and video games, in order to enlarge their market presence. So for patents, I believe that we have been through all the key issues here, because the situation in Poland is really similar to the one in Lithuania. So I will just mention that we can obtain a patent for some elements of the game. The game is not patentable by itself, but we can run through all the elements that we are using and just protect the ones that have this that do fulfill the criteria for obtaining patents. So, for example, we can obtain patent for technical solutions and for solutions with technical character, which are new, inventive, and industrially applicable. And all those conditions must be met at once. For example, we can obtain patents for game economy. We can obtain patent for the methods of vibration that have been mentioned earlier today, or even for forms of video compression, which is really important in the video game industry today, as the games are getting bigger and bigger. The main disadvantage from obtaining a patent nowadays is the fact that in order to obtain it, you need to disclose the data relating to how this invention has been created. So you are giving your market opponents the possibility of looking into what you are working on. So that would be the main disadvantage here. And so in order not to do so, we need to rely on protection for trade secrets and from the Act of Unfair Competition. Trade secrets have many pluses, and there are, in principle, it is unlimited in time. We need to keep due diligence in keeping our information safe, and we can use trade secrets to protect behind-the-scenes elements, such as, for example, source code or algorithms. And for example, the This issue is really important while making the game. We are using AI systems. So while we are uploading data into AI systems, depending, of course, on which system we are using, we might be no longer be protected because we are disclosing our data without keeping due diligence in keeping them secret. So secrecy also guarantees protection for elements that the entitled party does not wish to disclose, and that is the most important part. So another aspect is protecting of data, and in general, as many people say nowadays, data is the king, so data is the most important aspect in creating a lot of mechanism in the game, and especially in open world ones. So raw data is protected as a trade secret. In case it's structurized, we can talk about databases and the protection and sui generis protection under the Databases Act. And also when there's data and we have also some level of creativity, it can be copyrightable. So we can get copyright protection for our sets of data. So now, after the introductory part, I would like to talk about emerging trends and the future of IP in IP protection in games, which is for me the most interesting aspect of how the market is now developing. So first of all, we have a lot of user-generated content and a lot of IP challenges that are relating there too. So in terms of user-generated content, we can talk about reviews that are uploaded online, commentary-free guidelines, walkthroughs without additional commentary from the author of such walkthrough, and we have Let's Play piece of work that we can tweet, we can discuss under copyright protection also. So in terms of review itself can be protected under copyright because as long as it has individual character and appropriate form, we can itself protect it as our piece of work. In terms for reviews, we can also treat them independently, and we can use the right of citation for reviews under Polish regulations. Commentary-free guides are more tricky because we have basically no artistic performances and no creative elements during the walkthrough, even though a person can use specific mechanism in order to pass through a certain level, for example, of the game. All the mechanics, all the elements that they are using have already been introduced and prepared by the authors of the game. So we cannot state that, for example, passing through a certain level using different skills than normally required constitutes a work of art. In terms of Let's Plays, where certain user goes through all the game with additional commentary, it depends on the character of such commentary. We cannot say that it falls into the definition of citation here, but I believe that when the elements of description of the walkthrough of the game are creative enough, or maybe the game could be used only as as another element, and the main aim of the author would be to discuss some issues with the viewers and at the same time playing a game. I believe that this could be protected under copyright regulations. So there are three main IP aspects in terms of user-generated contents. We need to protect IP while allowing user-generated content. We need to have specific licensing agreement and terms of services, and we need to manage copyright infringement while using UGC. So the development, the producers and the developers are optimistic in terms of using generative content because they see the marketing potential there. So they normally in the US, they allow creators to use parts of the game on the internet, but it's can't be taken for granted. So we need to, each time a user uses part of the game online, he needs to be aware of the content of the EULA and whether it is acceptable by a producer or not. Another aspect are the AI-generated contents and IP challenges that it brings us. So, as a rule, only a human being can be the author of copyrighted work or the inventor of inventions protected by industrial property law, and that is the main issue here, and it's the main issue of using any AI-created content in preparing a computer game. So there are many elements relating to AI systems that can be protected. We can protect the input, we can protect the system itself, as well as some other elements, but the output is generally not protected as such. In order to obtain protection for such elements, we need to add some creative work from our side. So if you use the output of AI in your work, in general, this particular element is not granted further protection. So AI systems are not creators, non-inventors, and here I am just making general remarks. I know that some of the entities that have created their own AI systems do have special stipulations concerning the transfer of rights to the data prepared. But I believe that at this state of debate, we are not sure whether this can be enforceable, because for now there are no such cases in Poland, and the debate is still ongoing. So I believe that it's for the safe use of AI-generated content, there are a few rules that should be kept in mind. First of all, I would definitely avoid content 100% created by AI. I would suggest to add a creative contribution to any detail or any element that is created by AI. I would also recommend to, of course, to protect sensitive information while using AI systems, because the producers and the producers of the systems do not guarantee the protection of sensitive information, at least in the basic versions. I believe that there are some mechanisms that can guarantee such protection, but for customized solutions. I would also recommend to keep track of elements created with AI and to provide that and to create a database of such elements. I wouldn't use AI for important elements of the game, for example, for key characters or for key elements of the environment or buildings. And I would also recommend, of course, checking conditions for using AI tools for programming, for example. And there's this one more thing that I would need to go through today. So finally, there is this implementation of Digital Single Market Act in Poland with a 3-year delay. So since 20th September this year, we finally have this implementation. What it's about, it assures transparency while using online content. It also deals with fair compensation, and it clears the rules for reporting track revenue in game dev. There is also the exemption for fair use of video games fragments, which will be important for content creators, for user-generated content. We have also the rule of exploitation of work. So if the content is not distributed within the agreed time frame or within the 10 years period, the license will not, since the license was granted, it will be no longer valid. Also, license agreements constitute compensation for the use of such work. So what also changes, there's this one interesting point, that is the exemption relating to text and data mining, because according to new regulations, TDM refers to analysis of text and data in digital form, exclusively using automated techniques to generate specific information, such as patterns, trends, or correlations. So this exemption in the first version of the project, this exemption has not been included, which was publicly really which resulted in a heated public discussion about this matter. And finally, in the last version of the project, which came into force, we have this text and data marking exceptions. So it basically includes artificial intelligence system that learn by analyzing digital content or natural language processing tools, and it is available for cultural heritage institutions such as school or universities, and it's also allowed for reproduction of all already disseminated works or TDM purpose, regardless of the type of work on the entitled entity. There are two limitations for using TDM. So any entity that holds the copyrights can express their reservations. That is the first one. And the other one is that the work cannot be stored indefinitely, but only for getting necessary data. So these are two main exemptions. So I was planning to go through Accessibility Act, but I believe that we'll be discussing this later today, and there's no need to. And I would like to leave a few minutes for questions. So thank you very much.